Welcome to the Inventor's Edge podcast, where insight meets innovation. Whether you're sketching your first idea or refining a finished product, you're in the right place. Our mission is to equip you with the tools, expertise, and clarity you need to succeed as an inventor, while helping you conquer fears and limiting beliefs that may be holding you back. I'm your host, Scott Putnam, founder and CEO of Inventor's Edge. Before becoming a seasoned product development coach, I was a wide-eyed inventor with a head full of ideas but no clear path forward. I know firsthand what it's like to feel stuck, uncertain, and overwhelmed. Fast forward to today, I'm a successful entrepreneur with multiple licensing deals and products on the market. I'm committed to helping inventors like you overcome obstacles, conquer fears, and transform your ideas into tangible success through proven, actionable, step-by-step strategies that deliver real results. Join us as we bring in industry pros, share expert advice, and dive deep into the world of innovation. Ready to turn your ideas into reality? Let's get started. Today, we're thrilled to be joined by someone who has been on the front lines of invention for over 3 decades, Kevin Prince. Kevin's a registered patent agent and the founder of Quick Patents, where he and his expert team help independent inventors and small businesses protect their big ideas. Engineer by training, graduating from UC Berkeley, Kevin's also an inventor himself, the holder of 3 patents and the author of The Art of the Patent. He co-founded Inventors Forum in 1990, a nonprofit inventors group in Orange County, California, that's still helping people today. He's had multiple business wins, including selling his portable computer accessory company to a public firm and leading Grid Art, a product line that hit QVC, Michaels, and Hobby Lobby. Kevin brings not just legal expertise, but real-world entrepreneurial experience to the table. Let's dive in with Kevin Prince. Hey, Kevin, welcome to the show.
Thanks for having me, Scott.
My pleasure. Yeah, tell us a little bit about yourself and where you're from.
Well, I'm a patent agent, so I'm an engineer and went to UC Berkeley, got an engineering degree in industrial engineering, which is kind of efficiency engineering, if you will, and grew up in a family that was very much, thinking outside the box. My dad had 35 patents in his name, and so he was always encouraging us to, how can we make this better? And so it was a great way to grow up, and I ended up using this degree in a really interesting way because it kind of gave me a foundation on a lot of different engineering fields. I didn't go specializing in something. I just kind of had a broad general engineering education, which has really helped when, trying to help inventors on a particular project that they have that's a field I'm not really familiar with, but I can understand it enough to kind of get in there and hopefully write a good patent for them and protect what they came up with. And yeah. I'm an inventor myself. I have 5 patents with my name on it as the inventor. And now, after 20 years of working Quick Patents, doing this for full-time for 20 years or so, we have over 3,000 patents with my name as the patent agent. So it's kind of cool.
That's awesome. Congratulations. That's great. That's an accomplishment. That's a lot of help.
It took 20 years, but yeah, I think it's, it shows that we know what we're doing. And I really like this field because, it's always something new by definition.
Mm-hmm. Yeah, that's awesome. So how did you get into it? I mean, it sounds like background kind of more engineering based.
So I had a product idea in college. I was missing my alarms. I was sleeping through my alarm clock. And it struck me like, why should I be waking up at a specific time? Because maybe I'm in a low point on my sleep cycle. And when it's hard to wake up, really, shouldn't it wake me up when I'm at a peak, when I'm in REM sleep? So I thought of this idea of an alarm clock that would wake you up within a range of time, wherever your peak is, 45-minute range. And if it's, 20 minutes earlier than normal, it's going to feel a lot better if you're waking up, when your brain's already half started. So I found a patent agent and I had him do a search, and he found the exact same thing patented 10 years earlier. And so, I was bummed, of course, but on the other hand, I got to read a patent on what my invention was. It just didn't have my name on it. And so it was very illuminating to see how much detail you had to put into a patent. And
Hmm.
then I had other ideas, and we ended up getting some patents on those. And then that patent agent ended up hiring me to work with him to start his first location. And we did that for about 4 years. That's how I got into this business.
Nice.
I was just it's just always been fun working with inventors and coming up, seeing what they've come up with
Yeah.
that's new.
Always new creations. As inventors,
Yeah,
our brains are always going, which is
hopefully
great.
it's new. I mean, that's why we do a patent search to find out, right? But
Yeah, for sure.
if it is new, then we can talk about patents.
Yeah. Awesome. What was the agent that you worked with? Was he, I'm assuming, kind of a mentor to you and
Yeah,
take you under his wing and show you
yeah.
the
So,
ropes?
so when he hired me, I was an engineer, but I wasn't a patent agent, and
Hmm.
so I was able to write parts of the patent, but not the claims. And so he would write the claims, and doing that for 4 years, you kind of learned how claims work by osmosis. It was when I took the patent bar, that was the easy part, the claims, because I was already had 4 years, of experience with that.
Mm,
So it was a good education, and
right.
it was a good foundation for what I ended up doing.
That's super cool. So thinking about inventors, and you've worked with tons and tons of inventors, what would you say is maybe the biggest problem that inventors have in general?
Yeah, well, so the first problem that we inventors can have is that we like our idea too much.
Yeah, for
Because
sure.
we thought of it and we see the need, but really it's so easy, and I'm guilty of this. It's so easy to put a bunch of money into a product idea, and then it turns out no one wants it.
Hmm.
Or maybe I'm just a bad marketer. But the first thing you have to do is try to get some really honest feedback. Would people buy this? Like, are they going to take their credit card out and want to buy it?
Hmm.
And that doesn't count if they're friends or family. But, that's why I like Kickstarter, because Kickstarter is a measure of how much people are really willing to pledge, to with their dollars
Hmm.
to to see if they can get one of these products.
Yeah, that's a good point. Such a great measuring stick. Like, is my product any good? How good? And
Yeah,
you
it's
know,
it's it's like market research on a big scale. If you get
yeah,
enough people to put $20 towards your idea, then yeah, maybe it's not that hard to get other people to put $20 towards the idea.
yeah. Once all your friends and family are in, is anybody else putting 20
Yeah,
bucks?
exactly right. Yeah, exactly
That's
right.
so funny. With that in mind, so there's the idea of is my product any good? How about my patent? How do I know as an inventor, I come to you, you do a patent, it's like, great, okay. How do I know if it's any good? And what does that even mean to have one patent that's good and one that's not good?
Yeah, that's a really good question, because even with my first patent, I didn't really appreciate that it was kind of narrow. I mean,
Hmm.
we got the patent through, but it was at an expense of making it pretty narrow and pretty easy for a competitor to get around.
Hmm.
And novice inventors just don't have a really good appreciation for how claims work in the utility patent. In a
Hmm.
utility patent, claim one is the most important thing. When that patent issues, that's what this patent protects.
Hmm.
And so if
Yeah.
you don't, as the inventor, if you don't know how claims work, which is the section in the back of the patent, that's where you have a list of numbered claims, usually 1 through 20 or 1 through 15 or something. That's really the most important part of the patent once it issues.
Yeah.
And it's a good idea to educate yourself and learn how to understand how those claims work, because they're not even full sentences. They're really bizarre when you first read them. And
Hmm.
so you tend to kind of skip over, like, well, I'll let my patent agent or patent attorney deal with that.
Yeah.
And you really need to understand those, because if you don't, you're going to end up with maybe a patent that's too weak, or
Hmm.
asking for a patent that's so broad it's going to be easily rejected.
Yeah.
And that's the balance, right? Is the balance is, you can get a patent usually, but it'll be very weak by just adding things to the claims. But
Mm-hmm.
the more things you remove from the claims, the easier it is for the examiner to reject it. And so
Mm-hmm.
where is that balance? And, it may be that you can't get a strong patent on your idea. Maybe it's been done already.
Mm-hmm.
And that's where the patent search comes into play. You really want to understand the prior art and see, is it likely that I'm going to get a patent on this thing, that the point of novelty of my product, what makes my product new? Is that piece patentable? And that's where
Right.
you really have to ask your patent attorney or patent agent to explain it. Why do you think this is patentable over the prior art?
Yeah. And let me just jump in here too, because early on I thought, oh, the more information, the more claims, the more you dump into that, the better, the better protected. But the difference though is that if you're talking about an independent claim, if you have everything in your independent claim, including the kitchen sink, that's what makes it a weak patent, because somebody could come out with something that has a lot of the same things you have minus one or two that you have in your independent claim. They're not infringing. Is
That's
that
right.
right?
Yeah, that's right. And so a lot of people will read what I write for claim one, and they'll say, well, that's not what I'm selling.
Mm-hmm.
And I got to tell them, look, a patent is not a license to sell something. I'm not trying to describe what you're actually going to sell in the marketplace.
Mm-hmm.
A patent is a license to stop someone else from selling something,
Yeah.
making or selling something. And so I want to make it hard for a competitor to make your product or even a simpler product. Like, what's the core, the point of novelty, the thing that makes your patent unique or your idea
Mm-hmm.
unique and non-obvious? Maybe that's elements A, B, C, and D in the patent.
Mm-hmm.
Well, if you get a claim on elements A, B, C, and D, uh, a competitor, all he has to do is figure out how to get rid of D
Mm-hmm.
or A. How can he do it differently? Right? And if you have everything in there, the whole alphabet, it's a lot easier for the competitor to say, oh, okay, that's fine. I just won't use LEDs or whatever one of the components is that's not necessary. You want to
Yeah.
make sure claim one is the minimum viable product. The MVP. What is the minimum version? No bells or whistles, nothing optional. What is the bare bones version of your product that if
Mm-hmm.
you take one thing out, it no longer works or it's no longer recognizable as your product? If you
Yeah.
can get to that for claim one and you can get that passed through the patent office, then that's a strong patent.
Yeah. Yeah. I mean, a great example of that with my SWAT and scoop. I mean, the best independent claim, or the first claim I could have had, is just fly swatter. Okay, that's already taken. Then it's okay, fly swatter with a built-in scoop. Great. My patent attorney actually, when I started, had a lot of things about because when I was writing it, I put everything in the kitchen sink in there thinking, okay, that's going to protect me. But he put a lot of that stuff about special designs on the handle, and it must have some openings and angle geometry and whatever about the handle into the independent claim. And then we got that worked out, but it would have made an incredibly weak patent that
Right.
probably would have got issued,
Of
but it would
course.
have been very, very weak because somebody just comes out with a different handle, even if the scoop part, which is the magic,
Yeah.
was identical.
Yeah. So you want to be in claim one, you want to be specific about the magic. What's the key thing, right? And be general about the other stuff. It's just a handle. No details at all on the handle. It's just a handle.
Yeah.
Now, by the time you get to claim 19, yeah, maybe you've added some of those details in as dependent claims. The
Yeah.
dependent claims are the claims that say, the device of claim one, further including X, Y, and Z, right? That's where you put all the optional stuff. All the dependent claims should be considered optional. Anything that's optional should be a dependent claim.
Yeah. Yeah.
That's how to look at it.
Yeah. It's such a great distinction because it's dependent on the first claim, which is the independent claim.
Yeah, or claim 9 might also be an independent claim. At the end of the day, when your patent issues, the only things that matter are the independent claims. And so
Gotcha.
people are all excited. Oh, I got 20 claims, and I'm like, so what? How narrow is or broad are your independent claims?
Yeah.
Because that's what's going to tell you if some competitor is infringing you or not. The reason you have 20 claims to start with is because you want to give the examiner a bunch of boundary lines to do
Mm-hmm.
the examination. And they might say, after they look at the prior art, they might say, well, we're going to give you claims 11 through 20, but we're rejecting claims 1 through 10 because of the prior art. And So that's not bad because that means you're going to get a patent. The question is, are you happy with where they drew the line?
Hmm. Yeah.
If claim 11 adds element G, are you happy with A, B, C, and G?
Hmm.
Because if a competitor takes out G, he's getting around your patent. So
Yeah.
you gotta kind of understand that as you're prosecuting the patent, as the patent is being prosecuted at the patent office.
Yeah. It's such an important point because I think a lot of people just think, woohoo, I got a patent. And they have no idea whether it's strong, weak, or somewhere
Yeah.
in the middle.
Well, and people will ask me what's better, is a design patent or a utility patent, and it's like I've generally speaking, utility patents are considered stronger, but it's kind of like saying men are stronger than women. I've seen some pretty weak men and some pretty strong women, right? So you really have to understand what your claims are asking for. And in a design patent, the claims are really just the drawings. And there's some things that we can do in design patents that make it stronger as well. There's ways of putting optional features on the design patent drawings. So whichever way you're going, design or utility or both, you just want to be aware of how the claims work.
Yeah, that's such a great point. I think hopefully people that are listening, or inventors that are listening, this will help them as they approach researching patents. Because really, the main focus when you're looking at other patents that are kind of sort of similar to your product is that independent claim. I mean, that's where the meat of it is. So, whether I would think somebody can go in and just really just look at the independent claim and know how close is that. And then if you need to go further, you can.
Well, but it's a little different actually, Scott, because so there's two concepts that a lot of people confuse: infringement and patentability.
Hmm.
Those are two completely different things. There may be some overlap, but
Yeah.
the patent office is really only concerned about patentability. Do you have some element, element G in your patent that is new and non-obvious, and we can issue a patent on it? If they find that new element, let's say you have A, B, C, and G, and
Hmm.
by A, B, C, and G, I'm talking about the physical structure of your product. So you have an enclosure and a push button and a display and a rechargeable battery, right?
Hmm.
And if that's your product, and G is considered non-obvious and new, the patent office will give you a patent on that. That has to do with patentability. And
Hmm.
when you do a patentability search, you're looking to see if all of the elements that you have are represented in other patents. If there's other patents that have those elements.
Hmm. Right.
That's different than infringement. Infringement is where you would look at a competitor's patent and look at their claim one and say, am I making everything that's in their claim? Because it may be that you're making, and maybe they have a patent on A, B, and C, and you're adding G. Well, that doesn't help you because you're still making A, B, and C, and you're probably infringing that patent. Now, you might get a patent on A, B, C, and G because the patent office doesn't care about infringement. They only care about patentability. So
Hmm.
they'll issue you a patent that infringes someone else's patent. They
Right.
let the courts figure out
Sure.
who's infringing who, right?
Yeah.
So you got to kind of keep that in your mind too. It's there's two questions: are you infringing any active patents now with your product? And for that, you would want to do a freedom to operate search or an infringement search.
Hmm.
Those can be very expensive. We don't even do them. I mean, I can refer you out if you need to find
Hmm.
someone to do that. And then the other question is, do you have something new that's patentable? And that's where you do a patentability search.
That's such an important distinction because the company, let's say you have a patent with A, B, C, D, somebody comes out and those are in your independent claim. Somebody comes out with a product that they remove one of the things in your independent claim. They're not infringing on your patent. You wouldn't have a court case, but they're not going to be able to get a patent for it, right? That's infringement versus patentability. So it's such an important distinction and really interesting topics. And I think there's so many misconceptions that inventors have about patents in general. What are some other misconceptions that the average inventor might have about a patent?
Okay, good question. And a lot of I probably repeat this 4 or 5 times a day. People will
Yeah.
say, do I need a patent on my product? And the answer is no. A patent is not a license to make and sell something. You can do
Mhm.
it now. Okay.
Yeah.
A patent is a license to stop someone else from making, using, or selling something. And so if you want to stop competitors, then the answer is yes, you need a patent.
Hmm.
Okay,
Got it.
so that's the first thing. And then they're like, okay. And then the other misconception that's fairly common is, when I file a patent and I can legally say patent pending, am I protected? I must hear that verbatim a few times a week, right?
Yeah.
And the answer is no, you're not protected by patent pending. I could file a patent on an iPhone right now. Am I protected? No. I like to think that the way you need to think of patent pending is it's like a big no trespassing sign on a piece of property that you don't own yet. Okay, so hopefully that no trespassing sign will scare competitors away. You might not ever even know who you scare away with patent pending, right?
Hmm.
And what you're telling people when you say patent pending is that, hey, look, you already beat them to the patent office. So presumably you're first in line for this patent at the patent office. There's no point in them getting in line behind you because you don't get anything for being second in line at the patent office.
Hmm.
And so don't bother, right? As you're basically saying, I'm claiming this, I'm presumably first in line and I'm going to get the patent on it. But if somebody sets up a lemonade stand on this property and they start copying you, you won't be able to legally evict them from the property until you own the deed to the property, until the patent actually is granted.
Right.
Depending on what kind of patent that is, that could be 1 to 3 years,
Hmm. For sure.
So, no, if you just file a patent and someone copies you, you're not immediately protected. You're protected when that patent application gets approved, granted, and then you can go after it.
Yeah. Huge distinction. I hear it a lot, like even filing provisional patent applications. They want to file them so they have patent pending status so they can be protected, which technically they're not. It's like the beware of dog sign or the no trespassing sign until it's more official and something that's defensible. It's really what we're
Yeah.
talking.
Now, there are some tricks. Like if you have a pending utility patent and someone starts to copy you, and it might be 2 to 3 years before you get this patent issued, you can have the patent office publish your application early. And when you publish the application early, which takes them about 4 months from when you tell them, yeah, please publish my application early. Once it's published and you're showing everybody what you're asking for,
Mm-hmm.
you can then write a letter to your competitor saying, hey, we have this patent application that's pending. Here is the publication number. And we think that you are infringing the claims that we're going to get on this.
Okay.
And what that does is it means that your damages in court can start as of the day that you notified them of that publication. But two things have to happen. You have to notify them, and your application has to be published.
Okay.
That's one way to get retroactive damages. But you still don't know if you're going to get that patent necessarily.
Right. Yeah.
Right?
It still hinges on that.
Yeah.
Interesting. Wow. How about, when you talk about misconceptions with inventors, maybe the difference, and we could do kind of a quick overview of this difference between design, utility, and a provisional patent application. I think there's a lot
of people will say, I have a patent pending. Now, in my mind, what I think they mean is that they filed a provisional application.
Mm-hmm.
Okay. There is no such thing as a patent pending as a noun. Patent pending describes this as an adjective that describes the status of your application, whether it be a design patent, a provisional application, or a non-provisional application.
Yeah.
So design patents are one kind of patent, and utility patents are another kind. And utility patents have those two flavors, provisional and non-provisional.
Mm-hmm.
So when you say provisional, I know you mean a utility patent. There's no such thing as a provisional design patent.
Yeah.
And in fact, there's no such thing as a provisional patent. There's a provisional patent application, but it never becomes a patent. It's just a placeholder in line at the patent office waiting for you to file the non-provisional, the regular patent application,
Mm-hmm.
which will then be examined and hopefully issue as a patent later on, right?
Yeah.
So when you file your provisional utility application, your PPA, you can legally say patent pending, but only for a year.
Mm-hmm.
In that year, you have to file your non-provisional, your regular patent application. Then you'll go through the door at the patent office and get in line to get examined.
Yeah.
So those are the two types of utility patents. Utility patents cover how something works, as design patents cover how something looks.
Mm-hmm.
So the example I give is sunglasses. Let's say you come out with a new style of sunglasses. they work the same way as every other pair of sunglasses, but they have a different appearance or look. Well, you would need a design patent to protect that, because you're not going to get a utility patent on sunglasses. That's already been done, right? The way it works. But the styling, you can get a design patent on.
Mm-hmm.
Okay. Now, if you were the first person to invent polarized lenses, for that, you would want to have a utility patent, because you want to protect how those lenses are working to adjust the light waves. And you don't care what your competitor's product looks like in that case. If they're using polarized lenses, you want to be able to go after them. So that's a case where you would need to have a utility patent. And they're not mutually exclusive. I've gotten both design and utility patents for the same product.
Mm-hmm.
It's just they protect different aspects of the invention.
Yeah.
And sometimes you don't have the option for a utility patent. So a design patent's your next best thing, even though it's not considered as strong.
Sure. Yeah, I hear, the term like building a wall of patents. Is that what we're referring to here? Multiple patents,
Could be. Yeah,
protecting it.
it could be. This happens a lot. People will file a patent, and then 6 months later, it's like, hey, I improved it.
Mm-hmm.
Now what? Can we add this to my patent? Well, no, the answer is no. You can't add new matter, what the patent office calls new matter, to an existing application that's been filed.
Right.
Even a provisional. You would have to add that to your document that you made for your provisional and file it again as a second provisional.
Mm-hmm. Yeah.
And it's very common for that to happen. And then when you file your non-provisional, you reference two provisionals.
Mm-hmm.
One that was done in January and one that was done in July. But you want to make sure that you file your non-provisional still within that 1 year deadline of your first provisional. In that case.
Right. And the new art that you did in the second provisional, I know like the filing date is important. Is that new improvement protected retro to the first PPA because you connected the second? No.
No, the new matter gets the new filing date. And to the extent that there's old matter in your new application, that gets the original filing date.
Okay. Makes sense. I get that question a lot too about, well, what do I do when my PPA expires, or can I renew it? Can I add to it? Can I change it? Short answer is no, right? You just file another one.
The way I'd answer that is I would say, yes, you can add new matter to your document, or you could just refile your old PPA, but you're not going to get the benefit of that earlier filing date. That's gone. So when a provisional patent application expires, the year has gone by and you haven't cashed in that early filing date by filing it non-provisional, the PPA that you filed just disappears. It's as though it was never filed.
Right.
Okay. So now you have to rely on your next filing date. People will sometimes they'll say, well, look, I'm not going to be ready to file my non-provisional, by the 1 year deadline, which is coming up in a month. I'm not ready. And should I refile my provisional in a month? And I say, no, refile your provisional now. You want the earliest filing date because that earlier PPA is going away.
Mm-hmm.
So you want to get the earliest filing date that you can. That's today, right?
Yeah. And in that case, if they had a couple new ideas, they could put those in there as well and have a fresh PPA.
Yeah, absolutely.
Yeah,
but you get a new filing date.
Yeah, exactly.
So the effect is like you're getting out of line at the patent office and then you're getting back in line.
Mm-hmm.
Now, if somebody filed a similar application a month after you did, and they're second in line, well, now they move up to first place.
Mm-hmm. Yep.
Right.
That's
so you lost your
analogy.
Priority date. Now, usually I tell people, I think the odds of that are pretty low, but they're not zero. So it's a risk that you have to take if you're going to let that first PPA expire.
Yep. Such a good point. And I know there's a lot of confusion around all of this. And this day and age, when you think about the technology and things shifting, and I know this is could be a topic for a whole probably multiple podcasts, but in terms of AI and patents, do you have any thoughts on maybe big picture tools for inventors to think about?
Yeah. So I still think, and I've used a lot of these different patent specific AIs. I like a lot of them.
Mm-hmm.
But you still have to be a skilled operator to know how to ask the right questions or tweak it. I don't think we're at a place where the AI is just going to completely take over writing patents. It can help. It can help. It can help you summarize your disclosure. Like if you write a disclosure and you ask Chat GPT to, well, I wouldn't use Chat GPT because it's not necessarily private. But if you have one of these private ones or you have a subscription that's private, you can ask it to kind of summarize or give, the main features. And it does a pretty good job of that. And that would be good. Like I would want that input to be able to sit down and start writing claims. But I'm a little skeptical of when I've asked AI systems to write claims, I'm never fully happy with them. Of course, I'm never fully happy when I have one of my associates write claims either. So maybe
Sure.
I'm just too picky, but
Good thing.
I don't think we're quite there yet on
Yeah.
some of this technology, but it does look promising. And I think there's a lot of really good patent search, free AI patent search engines I've started to see. And I've dabbled with them. I've thrown a couple of my inventions in there. And, it's a good start to a thorough search. But I don't think it's necessarily by itself a thorough search yet. But absolutely use it if it helps you understand the structure of your invention, and if it helps you understand what some of the prior art is and what you have to look out for. Yeah, absolutely. It's good to try it.
Any specific tools you'd recommend in terms of, somebody that's listening, like, okay, well, Kevin, which one do you like, or what?
They're changing and there's so many new ones. I don't
Yeah.
even know. I just do AI patent search as a Google search, and a few pop up and I try them.
Yeah.
So,
Okay. That's a good tip. Or
yeah,
you could do a Chat GPT search for AI, or is that sort
I'm
of
not sure I
biased?
like chat for that reason. I call him Carlos. Carlos doesn't have access to the full databases. I think you want an AI that has access to the patent databases.
Sure. Yeah.
I don't know. Maybe the most recent iteration of Carlos does. I don't know. I haven't tried it for a while, but
Yeah. That's interesting.
it was like 2 years old data
Yeah. I know
when I looked at it.
this whole thing, like I joke, but it's not even a joke. It's changing by the minute practically, right under our feet. If somebody uses Chat GPT, is that considered public disclosure because it is going into some giant database somewhere?
I don't think that question's been tested in court yet, but I wouldn't want to be the test case.
Yeah.
Yeah,
Yeah.
it's better to make sure that you have a private session that's not going to be, reviewable by anybody at the AI company, or that's not going to get saved anywhere.
Yeah.
It's kind of like the age old question. Google has a pretty robust patent site. If you go to
Mhm.
patents.google.com, you can do a pretty good search. In fact, I have a class that teaches you how to do a very thorough patent search
Yeah.
on Google. The question I ask, though, is if I came up with a new search engine algorithm, would I really want to be typing that into Google?
Mm.
You know,
Yeah, that's a good point.
I'm not sure I trust Google all that much. So,
Yeah. I always wonder, where is all this information going? Because it's going somewhere and it's saved somewhere. So
right. And you got to be cognizant of export laws because you're not technically allowed to export your invention idea outside of the United States. But where are the servers
mm,
of these?
yeah, exactly. Good point.
If they're in China, that might
Yeah.
not be good.
Right. Yeah. Such an important topic and very timely. I will have to get you back on, another time to talk through more of the AI as it relates to inventors. As we wrap up here, any final thoughts for our Inventors Edge listeners?
Yeah, there's one thing that comes up a lot, and that is foreign patents. And the United States has a 1 year grace period. So what that means is you can launch your product on Amazon or wherever, load it up on YouTube, whatever, start Kickstarter, right? Try to start selling it. And you can file your patent a whole year after that. But most countries don't have a grace period. So the
Yeah.
second that you publicly disclose it, you can no longer file foreign patents in that country. China being the main one I'm thinking of, right?
Yeah.
And so if there's a chance that whoever you're going to license this product to, or maybe someday if a partner, a large partner wants to pursue foreign distribution, if there's a chance of that at all, keep it a secret. Keep your idea a secret until you file your patents in the United States. Then when you file your patents in the United States, you have another period of time that you can file your foreign patents.
Mm-hmm.
And you can go public with it after you file, because it's the filing date in the US that the foreign patents are basically going to be, that's going to be your effective filing date in the foreign countries under what's called the Paris Convention. Most countries have signed this.
Yeah.
And so if you file in the United States on January 1st and you launch the product on February 1st, for design patents, you can file your foreign patents up until June 30th, 6 months. Maybe it is July 1st. I think they give you that extra day. And then you can file your foreign utility patents a whole year later.
Nice.
So if you even think that you might have foreign filing options that you want to preserve, don't let your public disclosure happen before you file your patents in the United States.
Yeah. Great advice.
Yeah, that's the one thing that gets a lot of people. They don't realize. Like if they launch the product and then 2 weeks later file the patent, it's too late. You can't file your foreign patents in most countries. Some other countries have grace periods, but not many.
Yeah, hopefully that sticks around. It's nice to have that year grace period. Is that the same thing for a provisional, like the year grace period?
Yeah. So and the unfortunate thing there is now if you file a provisional, now your non-provisional is due in a year, and so are your foreign patents.
Same time, same year.
Right.
It's not like you get an extra year on top of that.
Right. And so that can get expensive,
Yeah, for sure. Well, how do people get in touch with you? What's the best way for people to reach out if they want to?
Yeah, best way is just look at our website first, quickpatents.com. We have a lot of information on there. We have order forms for all of our services. So you would just go up to the forms menu at the top and pick patent search or whatever you want us to start with. And then I'm happy to talk with people. I'll give you a half hour free just to get you oriented and get you on the right path.
Yeah.
Under the contact us, you can just say make an appointment and pick a time. We can do a Zoom call or a phone call. And I'm booking about a week in advance. So, in a week or so when we talk, then we'll get you pointed in the right direction.
That's so great. I hope people really take advantage of that because you are such a knowledgeable resource for people. You're easy to work with. Quick Patents, I mean, you definitely live up to the name.
Well, we try. Yeah, but unfortunately, most of the time, that's up to the patent office.
Yeah, not much you can do about that, right?
Yeah.
Well, thanks so much, Kevin. I really appreciate it. For everybody listening, please check out quickpatents.com and reach out to Kevin if you're interested and you want to talk and get some help.
Yeah, well, let's do this again sometime. That was fun.
Sounds great. Appreciate it. Thanks, Kevin.
Thank you.
Thanks for tuning in to the Inventor's Edge podcast. I'm your host, Scott Putnam, and if you enjoyed today's episode, don't forget to like and subscribe, leave a review, and please share it with fellow inventors. Your next breakthrough could be just around the corner. For more tools, tips, and resources, visit us at inventors-edge.com. Until next time, invent with purpose, innovate with passion, and bring your ideas to life.